Representative Feist, House File 104. Representative Feist is going to move House File 104, that it be placed on the general register, and there is a DE3 amendment. And Representative Feist, I assume you want to move the DE3 amendment?
Yes, Madam Chair. The DE3 amendment gets the bill into the shape that we'd like, and it also incorporates really helpful input from Representative Hudson, making language around mandated reporters more explicit. And that is at line 1.17.
Okay, so Representative Feist is moving adoption of the DE3 amendment to put the bill in the order in which she'd like to discuss it. All in favor, please. Okay, well, let's adopt the DE3, and I know there's an A1, and we'll adopt that afterwards. So all in favor of adoption of the DE3, please say aye.
Aye.
Opposed? Motion prevails. The DE3 is adopted. And then the A1 amendment to the DE3 that we just adopted looks like it makes a technical change.
Correct.
So Representative Feist moves the A1 amendment to the DE3. All in favor of adoption of the A1, please say aye.
Aye.
Opposed? Motion prevails. Okay, go ahead, Representative Feist.
Forgot my notes, and I'm just grabbing them. Well, I'm going to be extemporaneous because the written comments that I worked really hard on are not in my packet. So actually, no, I found them. You don't have to hear me be extemporaneous. I am pleased to bring House File 104 to this committee. It has two bipartisan or Republican authors in the Senate, and I've really appreciated the engagement by my Republican colleagues on this bill in the House. I've been working closely with system leaders and advocates for victims on this effort for the past year. I'm constantly inspired by their vision for a legal system that better centers victims and considers what they need to heal and move on. Under this legislation, statements made in the context of a restorative practice setting would be inadmissible in court, similar to the privilege that exists for alternative dispute resolution, or ADR. It is equally important to the successes of restorative practices as it is for ADR for there to be a legally safe space for dialogue so that the offender can accept responsibility for their actions without the possibility of their open, honest statements being used against them in another context. What this bill does not do is interfere with the traditional legal mechanisms for holding offenders accountable. Prosecutors can simultaneously or at a later date bring offenders to justice regardless of whether the victim chooses to explore a restorative path to accountability. This bill simply clearly delineates the bounds of the two separate processes and carves out important exceptions so information can be shared when necessary to protect public safety. We know from local and national statistics from the National Crime Victimization Survey and hearing from victims, survivors directly that the majority of crimes, more than half of violent crimes, over 2/3 of property crimes, and nearly 75% of sexual assaults go unreported, either because of feelings of shame or embarrassment, fear of retaliation, or not being believed, or not liking the options for accountability in the justice system. In order for us to truly be victim-centered, we have to listen to victims and provide more options for them to get meaningful accountability and the healing that they deserve. This is what victims have told me they want, and that is why I'm here today. And I will leave it at that, and I'll turn it over to testifiers.
All right. Thank you so much, Representative Feist. So why don't you testify? Go ahead. State your name.
Thank you. Good morning. My name is Amanda Sealing. I'm from Yellow Medicine County, which is actually a small county in western Minnesota. I'm the traveler, so it was about a 3-hour drive to get here. For over 15 years, I prosecuted sexual assault cases, juvenile delinquency cases, child protection cases in my small county, and today I'm here to ask you for your support for HF104. I don't know how familiar you are with restorative practices, so I'm going to take just a second to kind of explain some of the nuts and bolts. In Yellow Medicine County, for almost 25 years, we've been using a restorative practice called Circle. This is just one type of restorative practice. But through Circle, we've significantly reduced out-of-home placements and the costs associated with those, as well as recidivism, while simultaneously holding young people accountable for their actions. Other types of restorative practices are being used across the state in a variety of case types in a variety of jurisdictions, ranging from petty offenses to serious violent felonies. One of the fundamental tenets of restorative practices across the board is confidentiality. During the Circle process, learning happens through storytelling. Volunteers tell their stories. Young people or the offender tell their stories. The victims tell their stories. And making agreements to make sure that things that we say continue to stay in Circle. So what's said in Circle stays in Circle. That's one of the premises. And so in HF104, we're actually proposing that the things that get said in Circle get some legal protection. There's already a legal structure for confidentiality in similar things. I think that you should think of this as kind of analogous to the ADR process, right? So in 595 subdivision 1, 595.02 subdivision 1A, they actually carved out an exception to the ADR process. Let's be clear, this doesn't change the evidence that exists, right? Cases can still be prosecuted using all of the evidence that exists outside of the restorative process that's being used. It just protects the statements that are made during the restorative practice for the purposes of the restorative practice. This is a necessary change for restorative practices and for all participants across the state. The research is clear. When offenders take accountability for their actions, they're actually less likely to reoffend and public safety increases. When offenders take accountability for their actions, it benefits the healing process for victims. Confidentiality in circles and restorative practices encourages accountability. Please support HF104.
All right, thank you for your testimony.
Thank you.
Let's have, we have next testifier. I think we have Sarah Super and Alicia Nichols. Oh, no, we don't have those testifiers? Okay.
They're here, but I think for
Okay.
time.
All right, and we have another testifier, Sandra Weiss, who wanted to come up. And members, we can go just a few minutes over, and hopefully we'll be able to complete the bill. Welcome to the committee. If you could keep your comments just really brief. Thank you.
I will. Hello, Madam Chair Liebling and Scott, and the committee. Thank you for listening to me. My name is Sandra Weiss. I'm a local restaurateur, mentor, speaker, board member, advocate, daughter, and lifelong Minnesotan. I'm here to share my strong support of House File 104. As an adult in my 40s, I was attacked in the dark and raped like an animal by a known acquaintance. House File 104 is a tool for victims like me to mitigate our needs after such a vicious violation. This bill can foster reclaiming consent, apologies, and maybe even forgiveness one day that deeply matters. The tool can help both sides understand, make amends safely, and possibly heal. This tool is not for everyone, but will be invaluable for those that choose it. Our existing tools aren't working when a 40-something woman who is educated, successful, sober, and who's a cop's daughter does not feel comfortable reporting. If she questions she will be believed, who can successfully report? The terror of wondering if traditional reporting will actually help her or further devastate her life and the person causing the harm is the spirit-crushing reality of sexual assault reporting. That is why so few people report. Immediately after an assault, shock floods your body. Even brilliant minds fall victim to their faculties, failing them after sexual assault. It's a blur. Your worldview is immediately off kilter. Traumatic shock is a defense mechanism that helps protect your brain and body. It's accompanied by a range of physical and emotional symptoms, numbness, confusion, disassociation, and time and space seem foggy. Immediately, a rape victim is harshly judged on their ability to recall linear time, critical thought, and sharp details, all while physically tending to wounds, pain, shock, and insomnia. Making life-altering decisions is not recommended during a major life event, yet rape victims must instantly choose a course or wait and be judged as less believable because she waited. I'm almost done. Yeah. Most sexual assault cases are what is called he said, she said. And the courts, lawyers, and mediators will very quickly tell victims that they are very hard to charge and win. So it feels like society pushes victims to report, yet nothing happens. 6% of rapes are reported. These numbers may vary. 3% of those reported are charged. We have a flaming issue here. Victim needs a meaningful process, or why bother reporting? House Bill 104 allows victims to participate in a restorative justice process that is humane and finally their choice. Healing and moving on with life is more likely through mutual recognition of the mistake, and that's unheard of in a current civil process. When those have caused harm face their impact or their mistake, like she said, the awareness could potentially stop future harm. It's similar to the historic old-fashioned ways of community members brokered restoration together with both sides.
I have to ask you to wrap up, please.
Okay. Had this bill been available to me, I could have experienced healing, fairness, hope, and the justice I would have surely sought in a meaningful way much sooner. Today, I'm asking for your support of House File 104.
Thank you. Thank you for sharing your story.
Thanks.
So members, let's go to discussion. We have just a few minutes, but yeah, so discussion. Representative Scott.
Thank you, Chair Liebling. And perhaps it's in the bill here somewhere, if you're in one of these circles and a perpetrator, alleged perpetrator, admits to a crime that maybe he was charged for but not convicted because there was lack of evidence, what then?
So the way it works in Yellow Medicine
Ms.
County-
Sealing.
Oh,
Yes, sorry. Go
apologize.
ahead.
I'm a professor now, so I'm used to really informal conversations. The way it works in Yellow Medicine County is a youth gets charged with an offense. A person gets charged with an offense, and they make actually in Yellow Medicine, they make a factual statement on the record about the offense, and then they get referred to Circle. And the conversations that happen in Circle are the things that we need to be protecting, not the things that happen in court or anything that happened before court happened. In other counties, they actually get referred as more of a diversion process through the county attorney's office. And similarly, whatever agreements get made in order to make the referral to the restorative practice, those are the things that we're protecting are the things that actually occurred during the restorative practice. And so it doesn't affect the evidence that happened that led up to the charge. It doesn't affect any of the evidence that we've collected and gathered through investigation. It simply protects the conversations that occur through the restorative practice. Does that make sense?
Representative Scott?
Thank you. Yeah, it does. One of my hesitancies with all of this, and maybe you have some data on the effectiveness of this, but these are some really serious crimes that we're talking about, and I have a certain level of hesitancy and really uncomfortableness because I don't want to be letting anybody off that has done a heinous crime like this. And so, Representative Feist, is there data that proves that this is restorative?
Representative Feist.
Yep, thank you for the question, Co-Chair Scott, and I would be happy to share with you some data. I have a PowerPoint just talking about the impact on reduced recidivism. I think really remarkably, when you look at data around victim, it's kind of a weird way to phrase it, but like victim satisfaction, but off the top of my head, I believe it's like 94% of people who have been harmed who turn to a restorative process feel that that process met their personal needs. And I think 24% off the top of my head, but I think I'm right, 24% of victims see the traditional legal process as something that was healing and met their needs. So I think that it's very clear from the data that restorative practices are what victims want, but there is also really good data around reduced recidivism, reduce incarceration as a result. And Yellow Medicine County is so amazing because they founded their department, I think 2001, and you've been in one-ish, and you've been involved since the beginning. And so we have really wonderful data in Minnesota, from Yellow Medicine County in terms of how it's impacted their, cost savings from reduced out-of-home placement specifically for kids. And I'll turn it over if you have anything specific to add.
Professor Sealing.
Thank you. I actually wanted to affirm and validate those concerns because those were the same concerns that I had 23 24 years ago, when we first started this process, I was a baby prosecutor, and the idea of turning over my case to the community to handle it terrified me, because I didn't think that they'd be public safety oriented enough, and I didn't think that they'd do enough to protect our community. And what I found is that I was wrong. I was simply wrong. We are much better off in the justice system if the community is assisting and holding people accountable, because we have one probation officer, one judge, one prosecutor dealing with that offender otherwise. When we have the whole community helping that offender rehabilitate and come back to community, it's a much more effective way to prevent recidivism. And so I would encourage you, come on out and join us in Yellow Medicine County. We'd love to show you how the process works. But that's a slightly separate issue than this. And I think the really important thing to keep in mind is that this doesn't protect offenders at all. This allows offenders to go into a space with community members to take accountability for their actions. And it allows the victims to also come into that space and hear an apology. I spent years prosecuting people who wrote an apology letter. I don't know if you've ever gotten an apology letter, but it's not very meaningful. When I can look you in the eyes and you say out loud that I'm sorry for the thing that I did, and I can ask why, it's a much more powerful place for an apology to come from.
Professor Sealing, this doesn't give anybody the right to go through that process as opposed to
No.
the court process, right?
That's correct.
This is a decision that judges make about whether to allow this to occur?
Yes, and it allows for systems. In a lot of counties, it's a system-based system or a system-based program. In other counties, it's handled in a variety of ways. Nobody is required, nobody is allowed to override other people's decisions.
And this bill doesn't change any of that. All this bill does is protect those statements so that it can be more effective. This is a process that's already happening, and this bill is allowing it to actually be more effective. Is that accurate?
That's correct.
Okay. Representative Feist?
Yep, and I would just also add that this is something that the victims can choose. In no circumstances would this bill impact what rights people who have been charged or who have, caused harm, what rights they would have. It just creates that space for that dialogue.
All right. So we're kind of running out of time here. Is any other member comment? Representative Scott?
Thank you, Chair Liebling. And when we came into the committee hearing today, we were under the impression this bill was going to be laid over. And so my members are having concerns that the motion was to be made to go to the general register. And I don't know if it's your day to chair, so you can do as you wish. But I think some of our members have concerns, and so I will just say that.
All right. Well, thank you. Thank you, Representative Scott. What I would say is, I think the author wants to vote it out of committee today. It'll go to the general register. Obviously, we're a divided legislature. I think that Representative Feist is well-known for working across the aisle, and I think we'll be open to people's comments. I just have known her to work that way over the years, and clearly, this bill isn't going to go and pass off the floor if we don't have buy-in from a lot of members. So, I think it would be good to move the bill today, notwithstanding that members might still be a little bit uncertain about it. And I think the process can continue even though it would move to the general register. And Representative Feist, closing comment?
Yeah, thank you. And I commit to working with my colleagues across the aisle. This bill cannot pass without bipartisan support. So, we're moving it today, but conversations absolutely can continue. I really believe in this bill. I'm so grateful for the experts, the survivors, the system players who I've worked with on this for the past year. And I would be really grateful for your support today. Thank you.
All right. With that, Representative Feist renews her motion that House File 104 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails, and the bill is on its way to the general register. Thank you.